All right, everybody, on behalf of Trident Title, Performance Title, and Synergy Title, I want to welcome you guys back to Better Call Paul. Our special guest is live in New York City, straight off the floor of Wall Street, launching his initial IPO. In the house is Paul Krasker. Today, we are going to talk about wills and trusts and estates. We've had a couple of these questions come up from some people on the call and some people that are not on the call that are always kind of asking, what does the agent need to ask up front? What should they ask up front? What do they need to ask up front? If they're going on a listing appointment today, what do they need to know about wills, trusts, and estates to make sure, first of all, of course, their sellers are taken care of at the highest level. Second of all, that we can close them and facilitate the best possible transaction. And third, so that the buyers are not waiting around in limbo and, stuck and taking months to get stuff closed. So Paul, tell us what we need to know about wills, trusts, and estates. And if anybody has any questions, throw them in the chat and we will make sure we get them answered.
Sure. Thank you, Ryan.
Yeah.
So I'll start by saying this is an area that we want to be partners with you. We want to help you and we want you to know that we're there for you. So if you've got a appointment coming up and you want to call us and say, here's what it shows in the PAPA, and I want to go after this listing. What additional questions would you have? We're happy to go to PAPA with you, check it out, make sure that we understand it, and give you advice. But if you're just running out the door and you take a quick look and you see it's in a trust name or you see it's in a decedent's name, then the first question you want to ask at the listing agreement is, was this homestead property? If this was homestead property, then the surviving spouse may or may not have rights to the property based on homestead laws. It's possible if there was estate planning done and this was a second marriage, that the spouse has already waived their homestead rights and waived their elective share rights, but you really want to know what the status of their homestead is. Were they living here full time? Did they file their tax return with this as their address, etc.? And even though it may be in the name of the wife's trust, if this is their homestead, then the husband still has rights to the property, and you need to get that husband to sign off on the listing agreement and on the deed. If it's non-homestead property, a second home or the home of a third home or something of that nature, then the homestead issue doesn't come into play, and then you could just look at the exact documents. If the property's held in trust, you need to know who the successor trustee is. If the property was owned by John Smith and Mary Smith, and John Smith has passed away, then in all likelihood, Mary Smith is the trustee, and you can rely on her to transfer the property. But you still need to take a look at the trust, because the trust may say, well, when John Smith passes away, his son from a prior marriage becomes co-trustee with Mary Smith. And then in that case, Mary Smith doesn't have the ability to transfer the property without her co-trustee. So if you don't have the same people in front of you who were originally listed on the deed as trustees of a trust, then you need to ask them for a copy of the trust. If they don't want to give it to you because they say it's personal information, you say, I totally understand. We're going to need to see the trust to be able to transfer the property, but we use Trident Title or Performance Title or Synergy Title to do our closings, and we'll just need you to send the trust to them, and we should have you send it to them now, so we make sure that we've got the proper parties on the contract and the listing agreement, etc. So again, we're always willing to step in and help out, work as a team with you to make sure that you're not wasting your money by marketing a property that you don't have the ability to sell.
And if it were me, guys, as the agent, I don't know that I would even stress yourself out with trying to interpret someone's trust and I would just let them, like Paul said, ask them, who are the trustees. So if it's the Jane Smith and Joe Smith trust, and like Paul said, one is deceased, are there any other trustees in the trust that have rights, et cetera, but just let them know so that they don't get irritated once you go under contract. Whatever title company does the closing is going to need to see the trust to establish, who all needs to sign off on the sale of the property. Don't get yourself in an uncomfortable situation where you feel like you need to read their trust and interpret it. We're happy, to do that and let them know, because our underwriters are going to require to see that so that they can say, yep, this is in fact true, that this person has sole rights to sign off on the property. And,
So
do it that way.
agents, make sure we're staying in our lane, right? If we're an agent on the call, ask the question about homestead, ask the question about the trust, try to get it. Send it to someone that knows what they're doing.
Yeah, and you can give them my email address, Ryan, Paul, if they don't, people don't even want to give it to us sometimes. I mean, we even have to argue with them sometimes, but if they don't want to give it to their agent, completely understandable. You're welcome to say, if I give you their direct email address, could you just shoot it over to them so they can let us know before we get into this, to make sure that who has, who all needs to sign off, and we're happy to look over that.
Cool. Paul, what else? What else do they need to know with trusts and wills and estates?
Yes, the only thing on the trust side to say in addition is we really need to ask them to remember to ask whether there are any amendments to the trust or restate to the trust. Sometimes you get the original trust and you look at it and everybody mentioned is already dead. And you say, there must be some other trust document. Was there an amendment done? Oh yeah, sure. And then they send you an amendment or a restatement of trust from 3 years ago. So that's an important piece to ask for, not just the original document, but any updates.
And Paul, if property is in a trust, provided that it's a normal situation, will not need probate. Provided that all trustees are, someone that has the rights to sell the property is alive and able to sign off on the sale.
Correct, although I will say that that we have circumstances all the time, and I'm not sure if you know this, but 2 weeks ago we had a situation where the property was in trust, and we found out that the was created after the prior passed away, and the husband and his new wife had put this property into trust. So, when we ran our title search and we found out that the probate that was done for the prior wife wasn't done correctly, so we had to reopen that probate. So again, in all these circumstances, it's fact intensive, and get us involved as early as you can so that we can make sure that there are no issues. Trident and Performance and Synergy, we're always happy to run the title commitment. As long as we know we're getting the deal, we don't care if we run the title commitment now and then update it 3 months from now when you have a purchaser, but we're happy to get into the system, put it through the title plant, and find out if there are any B1 requirements that are oddballs that we can start working on now before there's an actual contract. So yeah, let's get all the information we can as quickly as we can. If it's held in a trust, then you shouldn't have to go through probate unless something crazy happened in the past. But it's better to have it in the trust than it is to have it in their individual names if one of them has passed away. So, and then with regard to wills and probates, if it was held in somebody's name individually and they passed away, a few things to say. Number one, you can't use a power of attorney for somebody after they're dead, period. You just can't do it. The power of attorney stops upon the date of death. So I've had several people say, no, we don't have to probate that. I've got a power of attorney. No, you do have to probate that. You should have executed a quitclaim deed as the power of attorney and transferred it to trust, transferred it to another family member before that person passed away. That was just, you're not understanding the law. So once somebody's dead, the power of attorney goes away. And at that point, you will have to probate the estate to get it out of somebody's name
And
and
Paul,
into a purchaser's name.
and just to throw this question out there, because I feel like it can be confusing when we talk about the trust, and if the trust names this person as successor trustee, you know, we're good, so to speak. If it's not in a trust and it's in an individual's name, so it's in mom's name, mom passed away. Oh, but here I have a copy of mom's will that clearly states that the property goes to me and I'm now the rightful owner.
Perfect. Now
Only-
we can probate the estate,
Right.
transfer the property to you. If it's homestead property, and it's been homestead for 5 years, then we shouldn't have to wait out the creditor period. We could just transfer it to you after we determine the creditor, after we determine the homestead status, and then you can transfer it out from there.
We'll still need probate was what, what I wanted to kind of,
You sure do,
it does-
100%.
unfortunately, just because the will says this is what happens, that doesn't unfortunately just transfer the property to that person.
Totally correct. Correct.
So I'm not sure if this is a question or what, but Pam in the chat said wife passed in April, husband passed in August. Both names are still on the tax roll and the property was willed to the daughter. There's a reverse mortgage on the property with no trust in place. I guess it would be, what do they do?
Yeah, if there's equity in the property, you open up a probate, find a purchaser, you wait out the creditor period, and then upon the end of the creditor period, you sell the property, use the proceeds to pay off the reverse mortgage, and then you keep the net equity.
Now you can, I'm not sure if this is right or not, but I feel like I remember you can sell the property before, just the money then stays in escrow until the creditor period is expired, or no?
Yeah, we used to do that. A lot of the judges in Palm Beach County are now saying, no, I want you to wait out the creditor period. So unless it's homestead property, and sometimes even if it is homestead property, they're getting nervous that claims will come in to challenge the homestead status. So what's been happening is people turn around and they say, oh, this was our homestead. Creditors don't get any equity from this, and just give us all the money. And then it turns out it was a second home. They lied about the homestead status to avoid the creditors grabbing the equity in the property.
Like thinking
So
they
now-
can take the money out first before anyone notices.
Exactly. And so now they're saying, no, let's wait out the creditor period, make sure there aren't any big creditors, and then we'll allow you, if it's homestead, to just transfer it out and those creditors don't get anything. But we want to have the ability for all of the creditors to challenge the homestead status. Then that's really more likely than what's going on right now. So we tell people you have to set a closing date at least 120 days after we open the probate.
Got it. Makes sense. Anything else they need to know, Paul?
Which is why they should reach out to us before you guys put it on the market, so that I can start the probate and I can have them appointed as PRs and have a motion to declare the property homestead before you're even marketing it. And when I've started the creditor period, then you know what date you can sell it. Exactly.
Someone's two questions. One is, how long is the creditor period on the first example?
Creditor period is 90 days. It's the
Okay.
shortest creditor period in the country. But that's 90 days from the date we give notice, we publish notice to creditors.
Yeah, makes sense. And then the probate roughly, I'm not holding you to the fire here. Roughly, how long is it taking?
If it's a summary administration, which means this is the only asset, and it was a homestead property, maximum of 90 days. If it's a formal probate that the value of the real estate was high and it wasn't homestead, or it's within 2 years of the date of death, and you have to do a formal administration, then that can take anywhere from 4 to 6 months,
Got it.
assuming no fights. Yep.
Okay, so Paul, I want to get into what I think is probably the one that's the most confusing. So we've talked about if the deed is just in an individual's name, if the deed is in the name of a trust. What about when you either on the deed or on Papa and it's the so-and-so estate? Or it's the so-and-so executor of blah, blah, blah estate. What do they need to look for on the deed and what questions do they need to ask to figure out who has rights to sign off on that?
Well, that's a good problem to have, because if it says, you know, John Smith as executor for Peter Smith, for the estate of Peter Smith, excuse me, I had to sneeze. If it says John Smith as executor for the estate of Peter Smith, that means an estate has already been opened, a PR has already been appointed, and that'll go very quickly. That means somebody's already ready to transfer that property.
Okay.
If it says John Smith as executor of the estate of Peter Smith, that likely means that the estate was administered up in New York or one of the other northern states, which uses the term executor instead of personal representative. And that may mean that it was administered up in the northern state, but still needs to have an ancillary probate filed down here just for this property so that you could sell it. That goes by very quickly. Again, if it's after 2 years from the date of death, there is no creditor period and you can sell it almost right away, but you still have to open up the process and procedure.
And what about if it just says John Smith estate?
That means that the property appraiser's office or the tax collector's office is now aware that that individual is dead, and it is referencing the fact that there's an estate that will need to be addressed.
Okay, so if they see on there John Smith estate, that's gonna need probate?
It could mean that they've already started a probate, but
Okay.
didn't have the name of the personal representative, or it could mean that it needs to be started from scratch. Yep.
Okay, so if something reads as John Smith estate, there's not necessarily a quick and easy answer of, okay, who has rights to sign for this property? There's gonna need to be
Correct.
a probate proceeding to determine that.
Then you want to go to the listing and say, was there a will? Have you started the probate process? If you haven't, certainly refer him to me, and I can have the conversations with him about what needs to happen when and how quickly we would like to move this forward. But yeah, all of those.
What documentation do I need as an agent to list the property that was willed to the daughter in that example from before? Does she need anything different or need to do anything different besides the normal paperwork?
So when in those circumstances, I never want to tell an agent not to sign them up, because if you don't sign them up, somebody else is going to.
Yeah, for sure.
So, but technically they're supposed to be appointed the personal representative of the estate before they can sign a binding agreement on behalf of the estate. If you sign it in the name of, let's say her name is Mary and her dad's name was Peter, and you say Mary Smith as personal representative of the estate of Peter Smith, then once she's appointed, it will be binding. Until then, I guess you could argue that she didn't have the authority and so therefore it doesn't count, but she'd still, if you took action based on her signing the document at that point, I think she'd owe you the money.
And then, I mean, if the names or something change, you could always at least do an addendum later, but I like the strategy of getting the listing, on the books.
Yeah, get it signed.
Yeah.
Get it signed for sure. You don't want anybody else out there. You'd rather have her thinking she's bound. And then, so if you're drafting it, that's the way I draft it. Mary Smith as personal representative of the estate of Peter Smith. You change the names to suit your purpose, but yeah, that's what you want to do.
Got it. Makes sense. Anybody else, any questions for Paul before we sign off? Going once, going twice.
I have a question, Ryan.
Go ahead.
To go back to the probate and the creditor period. So would it be 180 days if you had probate plus extending the creditor period?
No, the creditor period runs within the probate. So
Okay.
as soon as we get the personal representative appointed, the very next thing we do is give notice to any known creditors, and then we publish to all other creditors. And that is where the 90-day creditor period starts, when we publish in the newspaper. And then they have 90 days to submit their claims or forever be barred.
So it's not
Okay.
plus, it's simultaneous too.
Correct.
Got it.
Thank you.
Welcome.
Sure.
Anybody else? Any questions? Paul, if you get a chance tomorrow morning, go to Bagel Boy and freeze me one or bring one back. Trust me, it'll be worth it. Or you come home.
I already have to go to Zuckerman's and one other. So
Oh,
yeah.
All right. All right. Well, bring us home
Yes.
bagels. All right.
you got it.
And pizza, if you can smuggle that home too.
No chance.
Bye, guys. Thanks, everyone. Have a good day.